make sure that Christina is in picture. Good. So, welcome to another exclusive SUP workshop. And the purpose of this workshop series is to give entrepreneurs and startup founders quick and tangible advice on how to improve their startup journey, basically. Structure is, as always, 45-minute session and then 15 minutes Q&A. And for best experience, keep your mics on mute and webcams turned on. That would be way more fun for me and Christina. And recordings will be uploaded to our internal library and deck shared afterwards if necessary. And yeah, and thanks Bianca for coordinating and Svenskt Näringsliv for joining in, Hanna and Christina. Thanks. And once we get to the Q&A part, make sure you give us a survey response. So to give us some feedback, answer the survey, give us some feedback so we know how we can improve those sessions going forward. Yeah, it's my pleasure to welcome today's expert, Christina Wainikka. Is that correctly pronounced?
Yes.
Awesome. And she has 20 years experience in intellectual property and understanding how that very, very narrow, sensitive area works. And as we wrote in the preparations, these type of topics can either make or break your startup. So really happy to have you here, Christina. You have a deep experience on this. I'm going to leave it to you to give yourself an introductory of your bio. But really happy to have you here, Christina. Thanks so much for sharing your insights and knowledge to our community. Gonna leave the mic to you. Welcome.
Thank you very much. And we're going to start off with the real starting point, and that is that we are going to talk about make it or break it, because we're talking about intellectual property as something that creates value. So it's not just protect in the sake of protection, but rather how can we create value? And this value could be for the business as it is going along, but it could also be the key factor behind a successful exit. And one example is this: when Microsoft came out and said, we are going to acquire Activision Blizzard, the gaming company. And they said, we are going to pay $68.7 billion American dollars. And that is quite a lot of money. And if you think about it, it's just intellectual property. So it is copyright protected games. There might be some patents, and there are very, very strong trademarks that are held by Activision Blizzard. So this is sort of a starting point for what we are going to talk about. And this is me, as Sebastian mentioned some words. So I have a background as a legal researcher. I've been working with this value creation part of intellectual property for many years, and currently working at the Confederation of Swedish Enterprise. And Swedish Enterprise is an organization with 60,000 member companies, and most of them are small and medium-sized companies. So what are we going to talk about? Well, this is actually my father holding a light bulb as a symbol of innovation. But we are going to talk about knowledge-based assets. What are they? We're going to talk about innovation and IPR to give some more perspectives on innovation and IPR. And then we're going to sort of follow the structure that you might have as a startup, where you first come with an idea. Wouldn't it be cool if we could do this or that? then coming into a part where you as a startup are trying to create the idea more into something that you could put into the market, so making the ideas reality. And then you are entering the market. So what can you think about when it comes to IPR in those different sessions? Some points on strategies and some points on open innovation. And we are going to sum up with big do's and don'ts. Yes, where are the risks and where are the opportunities? So what are different knowledge-based assets? Well, you can cluster them into different parts. One is, of course, the non-exclusive rights. So where you have something that is worth something to the business, but you can't have it exclusively. You can't really exclude anyone else from at least creating the same. And that is, for example, data. And also business secrets and information that come up to information that will be kept secret and becomes a business secret. So you don't have an exclusive right to those type of assets, but they can be assets. Then we have the exclusive rights. There we have the patents, the trademarks, the design protection, and copyright protection. And there you have the exclusive part is that you sort of have a monopoly to that which is covered by the protection. And lastly, that I'm not going to talk about that much, and that is tacit knowledge. And tacit knowledge is something that you know and that you definitely use in a startup. And you also, when you're creating the team within the startup, this tacit knowledge is often crucial for creating that type of team. That tacit knowledge always belongs to the person, to the individual. And the thing that it is tacit is that you can't really communicate it. So let's say, for example, if someone's wanting to learn how to ride a bike, you can read a book about it, but you can't really ride the bike by just reading the book. You have to actually acquire the experiences and so on. And that is always held by the individual, and we're not going to talk about that in the continuing presentation. So, I talked about value creation, and before entering into the world on how innovation and IPR can link together, just some words on how important these assets can be, these knowledge-based assets. There is a company called Ocean Tomo, and they have looked into companies and the value of companies since the 1970s. And in their latest report, they look at companies and say, how is the balance between the tangible assets and the intangible assets? And now 90% of the value of a company consists of the intangible assets, so copyrights, trademarks, and so on. So that means that if you handle these rights in the best possible way, you can sort of grow the value of the company. In the EU, these companies that have intellectual property rights, they stand for 47% of GDP, which means that it's really important for the European economy. And then you see two numbers with exclamation marks. And I think actually 68% is more important to you, and 8.52% is more important to me. So there was a study in the EU when they looked into 127,000 companies within the EU and compared companies that had intellectual property rights and companies that did not have any registered intellectual property rights. And for the small and medium-sized companies, if they had intellectual property rights, the average was that they had 68% higher revenues than the companies that did not have any intellectual property rights. So that means that this has an impact on how much money you make. And those 68% are per employee. So it's really a powerful tool if you use it correctly. So that was the number for you. Seeing that this could be important for you, this 8.52%, that's why I get up in the morning, because in Sweden, only 8.52% of the SMEs have any registered right, trademark, patent, design protection, so only 8.52%. And that means that we are actually below EU average.
Wow, that's really, sorry to jump in here. Is that 8.5% of all registered companies?
Of the small and medium-sized.
Yeah.
Yeah.
All small and medium-sized companies. Okay.
Yes. And for EU, it's about 10% on average. So we need to get those numbers up because it can really have a big impact for companies. So I don't know if you have seen the playlist. It shows on Netflix, and it's about Spotify and the creation of Spotify. And if you watch that series, I really recommend it. You should look especially at episode 3, because in that section, there is an IP lawyer, and she's sort of the hero of episode 3. Because when it comes to innovation today, you can't really separate innovation from intellectual property rights. So they are closely linked together, and you need to sort of link them together all through the process. And we're starting off with a perspective we often have on intellectual property rights and innovation, which is a bit of a problem. And that is this perspective. Because we often think of innovation as invention, meaning invention as creating something, a technical solution like dynamite that Alfred Nobel invented, for example. And when we think about the innovation process, we often have the perspective that it's linear. So you come up with a great idea, and then you develop your idea, and then you enter into the market. And from that perspective, you think of intellectual property rights in the end, right before entering into the market, and you use intellectual property rights to create the monopolies. So, for example, Alfred Nobel, he could build his fortune by having the patent in the relevant markets. So that's one perspective. But there are other perspectives as well. So first of all, innovation is much broader, and most innovations are much more complex than just one technical solution. So you often have service dimensions, for example, to your innovation. You have digital parts of your innovation. It could be that you have a technology side, but also a service side, for example. Another thing is that you often have a never-ending innovation process, so that you enter the market, but you keep on developing. And also that what you do, first of all, you create the team, or you invite others to come with different parts of solutions, for example. So you have an ongoing innovation process. And that means that you need to start thinking about intellectual property rights rather early. Because if you invite people to your team and they are creating things that are important to your innovation, you must make sure that you could actually use that, what they have created. Because otherwise you might end up with a solution where you have the greatest innovation, but you can't really do anything with it. And lastly, from this other perspective, is that we use intellectual property rights to commercialize. So it's not just to create the monopoly, it is to commercialize. So we license, for example, the intellectual property rights. And one example is from this picture. We see I'm happy and smiling, having finished Ironman Kalmar. I think that was in 2016, that picture is from. And of course, Ironman can't own the concept of swimming, biking, and running. They can't have a monopoly to that, but they do own the trademark. So the race organizers in Kalmar, for example, have to pay a license in order to call it an Ironman race. And if you can use intellectual property rights to commercialize through trademark licenses, for example, that also means that you can use intellectual property rights to attract investments. So when you start talking to potential investors, you are describing, we own these intellectual property rights and we are going to use them in this specific way. So it's a different perspective than just creating a monopoly. So we're more into the business side of intellectual property rights. So, but when we start a business, so you think, I'm going to do something, then you have the idea. And how does intellectual property right handle ideas? And the simple fact is they don't. So when you have the best possible solution to a problem, you find a gap in the market that no one else has really discovered before. Well, intellectual property rights do not protect the idea as such. So you don't get patents for the idea at that stage. You don't get any other protection for the idea as such. But still, you might want to be able to communicate with others, for example. You need to discuss with potential partners within the team that you are creating and so on. So are there anything else that you could use at this stage? And I highly recommend that you look into the protection of business secrets and into the rules on copyright. Starting off with the protection of business secrets. So there is a legislation on protection of business secrets. So the legislation is there, but I would also say that if you are going to protect business secrets, you will have to take action, because the legislation says that you have to have done something to keep the information secret. That could be through instructions. If you have a policy, for example, for people coming into to the business in some way, or that you write non-disclosure agreements with people that you are involving in the project. A business secret consists of information. This information could be technical information regarding an invention, for example, but it could also be commercial information that you have found this customer group that no one has addressed before, like Pepsi Max addressed low-calorie soft drinks and addressing it to young men, for example, or Candy Crush Saga that discovered that the entire gaming industry had missed out on that perhaps women would like to play games as well. So that type of information could be kept secret. And it has to have a value because it is secret. So you have the information, others do not. And therefore, that information creates value for you. The protection that you get for business secrets is not an exclusive right. So if someone else develops the same information, they may do that. Reverse engineering, for example, is perfectly allowed. But they may not use the information or disclose the information unauthorized. And what might happen if you are a startup, you start discuss with different actors, is that they think that they can take the information. If you're aware of the protection of business secrets, you can communicate that this is a business secret. You cannot use this information without asking us for being allowed to do so.
So Christina, does it explicitly has to say that, or is it like commonly known that, like, what is the like the general approach to it?
I would say that in order to use this legislation, you must have made it clear to the ones receiving the information. And the law doesn't really say how you have made it clear, but you must have made it clear. And the thing is with protection of business secrets is that different companies have different attitudes to what information they're going to keep secret. So whenever you are sharing information that you think is to be a business secret, you will have to communicate that we consider this as a business secret. For example, when it comes to customer lists, we have, I wouldn't say hundreds, but we have a lot of court cases on customer lists in Swedish law. And for some companies, the customer list, that is their most important business secret. And therefore, we see all these cases. On the other hand, we also see companies that have their entire customer list on their homepage. So it's a different strategic decision that they have made. So therefore, you have to communicate, we consider this as a business secret, because it's not evident. Not all companies make the same decisions, and you can't really know what the other party is thinking. So you must make clear to them, you consider this a business secret. I think we have a question from Annika.
Yeah, jump in.
Thanks. I don't know if code base is integrated in this part. We have a friend company, so to speak, where they employed a developer, in this case a French who stole the entire code base, launched another company. It went up into French court, and the French court took the French developer's side, and basically the original company folded and restarted on the same brand name. But I have no idea if they did any NDAs or something with that. But it seems a bit weird that you can steal an entire code base as a consultant or employee, even if the company hasn't written anything specifically. So that's interesting.
And I would say that there are some weaknesses here. And I would say the biggest weakness is, especially if you don't communicate what you think is supposed to be kept secret. And especially, I would say, if someone hears me lecture on the protection of business secrets, I often point out just specifically France as a problem. Actually, and that is for historic reasons. Nowadays, we have an EU directive on the protection of business secrets, so it's supposed to be harmonized. But in the old days, before the directive, the French protection for business secret was aiming at established companies that already had an established position on the market, whereas our legislation not only focused on those companies, but also on the startups. And in creating the directive, the directive is quiet on specifically that point. So we don't really know what is the EU law in this field. And we shouldn't keep digging into this, but there are national differences. And that means that if you are working, especially with people from France, be specifically clear, right? Specifically clear NDAs, because you need it, because there's a cultural difference here.
Thank you so
much. Great question and great answer. But doesn't that sort of, just to comment on what you said, isn't the purpose of harmonized law to avoid this deviating legislations or thoughts. So then it's like then the whole system falls apart. Or
yes, and for those of you who read Swedish, I just come up with a commentary on the Swedish Act on Protection of Business Secrets, and I'm digging into where the directive gives us guidance and where it does not give us guidance. So you can look for that. I know it's available on Focus, for example. So leaving that, also mentioning something about copyright protection. And copyright protection could be useful when you are, for example, handing over documentation. So you have a presentation of your idea, and you hand over that. We have a PowerPoint presentation or something that will be covered by copyright protection. The problem with the copyright protection is that it does only protect the expression, not the idea itself. So it doesn't really cover the idea of your business. But on the other hand, it is a copyright protection. So if you are coming to a meeting and you see that you handed them one copy and now there are 10 copies at the meeting, then they have done something that is not allowed according to copyright law. And if you are going to court, for example, it's very useful to use the link between copyright protection and protection of business secrets. So do have handouts also so that you can communicate to them, make sure that it says that it's supposed to be confidential and that it is protected by business secrets, and make sure that you have documentation on who you gave this documentation to. Because also copyright protection is easy to communicate. There's no need to register anything, you just put the copyright C there, and people are realizing there is a protection here, and the ones giving me this documentation, they are aware of that there is a protection here. So use copyright protection, but be aware of the fact that it does not cover the actual idea.
So just to clarify what you mean here, like how do you get copyright?
So copyright protection is there when you have created something. So if you have made a drawing or taken a picture or whatever, it is there. So no need to register, not to do anything. And one thing that you must be aware of is that it starts always with the individual that creates. So even if someone who's employed or if someone is doing it as a consultant, it always starts with a physical person. So that is the right holder. So that's why you have to think about copyright protection really early and make sure that you have all the agreements in place. But we'll come to that. So now we are taking the step further away from the ideas. We're making them a reality, and we are coming back to this children's character later on from Babblarna. And here we are able to protect different things for our business. And some of these protections require action, that you need to do something. And we're going to start off with patents. So patents is something that you can get for inventions, for technical solutions. And there are differences on how technical solutions are interpreted in different parts of the world. So we had a seminar last week. So if you understand Swedish, you can go to our homepage and find a seminar on digital innovation, because it is easier to patent digital innovations in the US compared to Europe, for example. In order to patent, the invention has to be novel, it has to be new to the world, and it must have inventive step. So not just easy solutions, but it has to require some type of research and development. And one thing that you need to look into as well, if you're working with technical solutions, is that you have to look into freedom to operate, to make sure that no one else has patented the technology that you want to use. And in order to get a patent, here you will have to take active steps. So you can register in different ways, but you must register. No registration means no patent. And also this novelty requirement in Europe, you will have to keep information about the invention secret before you patent. If you have published anything, the patent road is closed. You can't go that way. So you will have to think about, are we interested in perhaps patenting this? Make those decisions early, because otherwise, if you try to make the decision later on, you might fail. You might not be able to get the patent. And there are different ways to get the patent. You can register nationally. EPO is the European Patent Office, and if you go there, they have 39 member countries, and then you designate the countries, so you choose the countries, so you don't get all the 39 with one application, but you have to choose which countries to apply for. And that is the same with PCT, Patent Cooperation Treaty, which is broader, even more countries, but you designate different countries. And with each new country comes new costs, of course. And UPP is the unitary patent protection that will start on the 1st of June of this year. And that means that you apply for a patent and you will get in 25 of the EU countries with one application. And when you apply for a patent, you must really think of the fact that the registration is linked to the specific geographic area. So in all parts of the world where you have not registered, it is still free to use for anyone. And that means that you do require strategies on, for example, where to patent. I had a discussion some weeks ago with a company that said, oh, we're going to move production to Sri Lanka. And fine, you may do that. And they relied very heavily on patents. Did they have any patents in Sri Lanka? No, they didn't. Well, they should have thought about those things before thinking of moving all the production to Sri Lanka. Another important thing is to think about when you apply for a patent. And it's just as bad to apply for a patent too early as to apply for a patent too late. So, for example, if you apply too early, perhaps you haven't really figured out what your business model is going to be. And if you do that, you might lose sort of protection time or not having an idea what to do with a patent. And then the patent is just going to be a cost because you have to pay application fees and annual fees and so on. And I've actually met a startup, and the duration of a patent is a maximum of 20 years from the date of application. And they didn't think of a business model and a business case around their patent until they just had 6 years left of the patent protection. And then why did you apply for a patent that early? You should have an idea of what to do with a patent. But the problem is also if you apply too late for the patent, if you are in a fast-moving industry, perhaps other companies come up with the idea. So you really have to think about, what are we supposed to do with this patent? Why do we need it? And why should we apply for a patent at this moment? So not too early, not too late.
Question.
Yes.
like what type of costs are we talking about here? Like let's take this united thing for 25 European countries. Like what does it cost per country?
I'm not sure what the fee is going to be. For one country, it's normally around 5,000 to 6,000 cost in the registration fee.
Swedish krona?
Yes, Swedish krona. But, and then of course, if you add more countries, then it's more and more expensive. But with this unitary patent protection, it's going to be cheaper. It's going to be sort of a discount per country. Yeah. But I would say that the big cost for applying for patents is that you are going to need help to get the patent application correct. So you will need to have a patent consultant and a patent attorney. So when we say that patents are costly, that is mainly because you do need the help of patent attorneys. Because if you don't, your patent is just going to be a cost. It's not going to create any type of value. And there we talk about perhaps a starting point from 100,000 crowns, if it's going to be useful. And if you are going to create patent families and so on, you could end up with perhaps 1 million crowns. But for the ones using correctly, knowing what they're doing, that 1 million crowns could be definitely worth it. So the big cost is you need to have the help of a patent attorney, definitely. So don't try and do a patent application yourself. I would never, ever, ever recommend that to anyone. Because you will need that help, because if you don't, you will end up with something that you can't really use. It won't serve you any good. So it can cost, but it can be extremely useful if used correctly. And the registration cost and so on, those are sort of the smaller part of the cost. It is the consultants that you will need. You can't make those type of decisions by yourself.
Is it like, how many hours of work are we talking? Because I'm assuming it's both the consultant and the organization or the product experts that needs to be involved.
Yes.
And strategy as well. Like, what are the, like, from what you've seen on the average, I know the answer from you as a lawyer is it's going to be, it depends. I'm gonna push you a little bit harder. Like, are we talking weeks or months, or like what are the typical timelines?
I would say it depends also on how well aware the business itself is on both sort of the level of technology and what the situation is when it comes to, for example, competitors. So perhaps when you've started your road on patenting, you have done perhaps a freedom to operate analysis. And if you have done that and you're well aware of what competitors there are in the market and what they have patented before, then the costs and the difficulties of the applications, they can be diminished. So it does depend.
Got it. Thanks for the answer. Annika, feel free to jump in.
Since I just have a theory which might be wrong, since the Swedish startup world, it's to such a large degree software, and from everybody I talked to before you say that basically you can't patent software, at least within the EU, then you have to go to the US. Maybe that's a question why nobody bothers to do it.
Yeah, and that is true, and that is why I mentioned this seminar on digital innovation, and that's the difference in patentability. So in Europe, it is more difficult to protect digital innovation including software. Software is protected under copyright protection in Europe, so we rely heavily on the copyright protection. There are some possibilities to patent, depending on how you sort of structure the patent application, but it is really difficult in Europe to patent. And I can mention this company, for example. So one of the speakers on the seminar that you can see still on our webpage was from Spotify, and he described how their portfolio of intangible assets, how is that constructed? So of the different assets and how they think about protection. And a company like Spotify, they do have patents, especially in the US, but they can't rely on just patents. So you can't really rely on just patents if you are that type of startup like Spotify once was, at least. But sometimes it could be useful to apply for a patent, especially if you are to talk with investors. Some investors are really heavily looking into, is there a patent? And sometimes they don't even evaluate the value of the patent. They just see, oh, there's a patent, and they're very happy about that. So perhaps in some situation, from a strategic point of view, perhaps apply for a patent, but know that it has very little value.
Before we continue, just like one trick that I've seen is the patent pending trick.
Yes. Exactly.
Could you just enlighten us what that trick is?
Well, the trick with patent pending is that if you apply for a patent, it takes a while before it gets approved and you get the actual patent. And when you have the patent pending, it could go either way. It could be accepted and be patented, and or it's not, because the invention perhaps is not patentable. So therefore, if you're meeting with investors, sometimes you apply for patents even though you know that it's not going to be approved, just to make sure that you're more interesting for investors, for example.
It could also be like a proactive way of protecting yourself from competitors as well.
Yes.
It's
yes,
like
absolutely.
Sometimes the best protection is to convince others that don't even try to fight us.
Yeah.
Right?
And that is the same thing as I mentioned before, when you start to discuss with people about your idea, if you make sure that you communicate that I have these rights, then people are perhaps a bit reluctant to just taking your ideas, rather than if you just come and say, oh, these great ideas. But if you show that I know I have a copyright protection, I know this information is a business secret, and we did apply for a patent. So you do create another image of yourself, which could be very useful. So when you're entering into the market, you need to think about communication. And for communication, do use trademarks. And when it comes to registration of trademarks, it is much cheaper to register. So for a Swedish trademark, the cost is 2,000 Swedish crowns, and the trademark is valid for 10 years. If you apply for a European trademark, EU trademark, the fee is 850 euros, and you get protection within the entire European Union with one application. And trademarks are extremely valuable. So work with your trademarks and create value with the trademarks. We can all think of companies that, of course, there's so much more than what we see. But when we talk about the companies, we talk about them without trademarks, like Uber, for example. Mainly it is a trademark. So communicate and think of the trademarks. And when you are creating strategies, you will...
Sorry, Christina. Sorry
Yes.
for like jumping in and slaughtering your your momentum here. But I just
Yeah.
have another question on the trademark.
Yeah.
Does that require consultancy as well? And how much?
No.
Okay,
I
nice.
would say for trademarks, of course, there are really, really great trademarks consultants out there, but you don't really need consultants to that type of extent that you do need with patents. So patents absolutely don't do a thing without discussing with a smart patent attorney. Trademarks, we often have discussions on trademarks, and it's just as easy as to buy tickets when you want to go to the movies or order dinner from Foodora. If you have done your work on what you want for a trademark, go ahead. If your application is not approved, you have wasted 2,000 crowns if you do a national application. So this is something you can do for yourself.
Awesome. And the European version of that?
It's the same thing. Same thing. So
same
it's
price or same?
Yeah. So you can do it yourself. You pay with your credit card on your way out. So you do it online, do it yourself.
And what's the name, the official name of the European trademark?
That is the European Union Trademark Community Trademark, and you apply for it through the EU IPO. EU IPO, so European Union Intellectual Property Office.
Perfect. Thanks. Sorry, continue.
Yes. So the thing with the strategies is that you have to think about what you want to achieve, and perhaps you recognize this little Angry Bird. And one of the things with Angry Birds is, from one perspective, you could say Rovio that created Angry Birds, they're a gaming company. So a business model would, of course, be that we sell games so that people are paying us for the games. But we know from their business model is that they gave games away for free. And immediately you could see that their business model was balancing incomes from the actual games, but from merchandising. And that could be a strategy to actually give some things away for free because you want to create something else. So strategies should always be based on what do you want to achieve. And you have to start with the things like acquiring the rights. What rights do you have? What can you have? What are we going to do with those different rights? That's where the starting point should be. Especially focus on the purpose. Why do I want this specific right? I too often see startups applying for patents without even thinking about what should we do with the patent, for example. And when it comes to using the rights, that could be part of the innovation where you're commercializing through the intellectual property rights, for example. Like McDonald's, the big McDonald's corporation, they don't sell hamburgers. They are franchising their business model and all the trademarks and so on to others. So they're commercializing through the intellectual property rights. And here comes, of course, the playlist where the business lawyer came in and actually was involved in creating the actual innovation of Spotify. And, of course, the agreements. And here comes the Babblarna case, because the problem with Babblarna was that they did not have clear agreements on the rights between the illustrator that made this figure and the company that had created the business. And that ended up in court. No one ever wants to end up in court. It's just a waste of time and money. So when thinking about agreements, you should think about who should own what, who should control what, and of course, focus on what is really important to make sure that we can do what we want to do. Because the problem is, if you don't have those agreements in place and you have this fun, open innovation process in the beginning, you might end up with a great idea that no one can use because no one controls anything. So think about the agreements, especially if you're creating a team working with developing something. And that also links to open innovation. Of course, open innovation does require active decisions, especially if there is something linked to copyright protection. Since copyright protection is not registered, you will have to have agreements with people contributing to the innovation process about their copyrights if you are going to let it out free on the market, because otherwise you're just creating a bunch of copyright infringements in those different rights. So some conclusions. When we talk about innovation and intellectual property rights, we talk about business risk and opportunities. The biggest risks are, of course, that if you make no analysis of what intangible assets could we have here, when you don't have strategies on how to create value through these intellectual property rights, if you start discussing with all types of people without any non-disclosure agreements, if you don't write any agreements with people creating parts of your innovation, and if you don't make your registrations, you don't register the trademark, you don't apply for a patent when you could or should. So those are the risks. On the other hand, we have the opportunities where you can see that the small and medium-sized company has 60% higher revenues per employee if they have registered rights. Here you have a great opportunity. And for Activision Blizzard, the gaming company, that enabled them to make a powerful exit worth of 68.7 billion American dollars. So you can create value and have great opportunities. To think about is, of course, what creates value. And if you want to subscribe to a newsletter from the Confederation of Swedish Enterprise, you could scan the code. And if you want a newsletter on intellectual property rights, you can email directly to me. And with that, I know I've talked too long, but we took some questions in the meantime, so I hope that's okay. So
yeah.
Any more questions or comments?
Awesome, perfect. Thanks so much for that, Christina. Really, really valuable. I have some questions lined up that I felt a little bit too uncomfortable interrupting you again. So, but I'm going to leave it first to the others to jump in if they have anything before I ask. Anders, you're muted. I don't know if you want to jump in.
Actually, I just wanted to thank you for a great presentation. You covered all the areas that I had questions around. So really, really good, and thanks a lot for that. And what I didn't have answers to, you, Sebastian, completed with. So thanks a lot. Great.
Thank you.
Good. Happy to hear that. Feel free to raise your hand if anyone has any questions. Otherwise, I'm going to spend a couple of minutes just running through some of mine that I know companies think about. I'm going to start with the reflex for startups when you talk to investors is to throw an NDA at them. It's like, sign this before I tell you my super secret, mega, ultra things. And most experienced investors say, sorry, I'm not signing any NDA, because it's like, I see thousands of business ideas within your domain, your vertical every year. So sorry, I can't. Like, what are the best practices here from your point of view?
I would say, first of all, have a strategy on what you are communicating at what stage. So when you are discussing the idea in the first stage, don't give away the specific business secret And one example again from the playlist on Netflix. If you look at Spotify, the problem was to one extent that they did come and say, we have this idea. And they said, oh, we've heard about those ideas. But the core was actually the technique, the technology on how to make it play directly. And that is, of course, something that they should not communicate, just prove that we can do this and others cannot. So the most important thing is to have a strategy on what you're communicating, when you're communicating it, and how you're communicating it. And at least, according to some legislations, it's enough to say this is supposed to be kept secret. So you don't have to have an agreement where they sign and say, we accept that this is to be kept secret. So if you come to a meeting, you make sure that you document who is at the meeting and you hand over information to them and it says confidential. That is enough to bind them to that confidentiality.
Nice. One last question from my side that I think we have time for is sometimes we are on our side writing blog posts and writing articles and citing and quoting a lot of good sources and smart people. Like what's the best practices here? I'm allowed, if I share the source, reference the source, I'm allowed to share it, like, right?
Yes. So I would say the easy answer is yes. So if you post a quote and then a link to original source, I would say that is perfectly allowed. But of course, if you dig really deep into copyright law, that there are some complications. But I would say at a general level, if you quote, so you don't take the entire article, for example, or the entire book, but you take a quote and then you link to the original source, I would say it's perfectly allowed.
What if you copy paste the entire article?
Then I wouldn't be too happy. Then you are perhaps making a copyright infringement.
If you ask them for permission?
Then it's perfectly allowed. Yeah.
Good.
And I would say one also recommendation is, of course, do ask questions.
Yep.
So you can call, you can text people and say, could I please?
Yeah.
And if they say no, then you also know that you have probably are dealing with someone who might be a little bit aggressive about their intellectual property rights. So you back down.
Yep.
And if they say yes, perfectly fine. And then I would also often write an email or something to just confirm. I understood that we can use this article for this purpose. And if they do not protest under contract law, then we have an agreement. Yep.
So I'm gonna wrap it up there because we're out of time. Christina, thank you so much for tuning in and joining us and sharing your experience. And thanks for everyone joining. We have I did not push the poll, but if you still have Anders and Madi, if you want to answer the questions, that would be great before we wrap it up. And next up is OKRs and goal setting. We have stress management. We have HR and no code on the topics going forward for dedicated sessions. And we will jump on a fireside chat on our socials to wrap things up with some external stuff. So if you want to hear more from me and Christina for a couple of minutes, then we'll be on our socials. Thanks.
Thank you
very much.
Bye.